Associate Counsel with 1199 SEIU United Healthcare Workers East, where we are happy to host this meeting. I'm also the current New York City Lera chapter secretary this year. Our president, William Herbert, is here, as well as our vice president, Ayanna Blake, is present as well. This is our second New York City Lera program for this spring, which is the Workplace Immigration Law Update. And we have another coming up on June 13th. Bill, what's the
mental health in the post-pandemic workplace?
Mental health in the post-pandemic workplace. That's scheduled for June 13th. I hope you will all attend. This panel is regarding workplace immigration law update. Then we will be discussing immigrant employee rights and employer obligations and best practices in hiring, employment, and discharge, navigating layoffs and mitigating the impact, temporary protected status, work authorization, and the deferred action program serving the needs of immigrant workers. A copy of the PowerPoint presentation that's on your screen has been emailed to all that have registered today. Before we start, our speakers today are Hamel, Vyas, and I'll let everyone introduce themselves and give us a little background.
I am Hamel Vyas. I am Senior Associate Dean for International Personnel and HR Regulatory and Compliance at the Mount Sinai Health System. I'm an immigration attorney and been practicing immigration for several years. And I'm a universal citizen, born in India, grew up in Canada, and now I'm in America. And I love what I do.
We also have Ingrid Nava.
I'm Ingrid Nava. I'm Associate General Counsel at SEIU Local 32BJ. I am a labor lawyer, but for all of my career, I've worked with immigrant workers. And so for all of that time, dealt very much with the intersection between employment and immigration, employment, labor, and immigration law. So I'm happy to be here.
And we have Cora-Ann Pestaina.
Hi, I'm Cora-Ann Pestaina. I am a business immigration attorney, handling all types of employment-based immigration cases, also handling some family-based immigration, but mostly 80% business, 20% family.
And as a quick through for the agenda today is we're going to do an overview of the government agencies involved in the immigration process, a common employment-based non-immigrant visas, the employment-based green card process, termination of a foreign worker, temporary protected status in DACA, Form I-9 compliance, employer obligations to verify, re-verify, and anti-discrimination issues. We'll have some time for questions and answers. If you're joining us via Zoom, please feel free to enter questions into the chat forum, and we have our president monitoring the chat, and he will present the questions to our speakers. This program is also CLE certified, and you should have received the presentation materials, evaluation form, and CLE affirmation form. For those of you requiring CLE credit, please record all attendance verification codes announced during the program on the affirmation form that was provided. Please complete and return the form as indicated at the bottom of the form after the end of the program. So there'll be 2 times during this program where I will be stating a code. Keep your ears peeled and write it down into the form that's been sent to everyone that's attending via Zoom. For those of you in person, all you have to do is sign in, sign out, and that should be it. Again, for those of you on Zoom, please post your questions on chat, and why don't we take it from there?
So as we get started, before we get started, I think it's important to understand the regulatory authority and the laws that oversee all the immigration aspects. We have the Immigration Nationality Act that was created in 1952, and there have been several amendments since then. It's also codified within the US Code. You'll find most of the immigration regulations in Title 8 under the Code of Federal Regulations. And normally if there are going to be any changes, they're posted in the Federal Register, open for comments before they finalize them. And then the Foreign Affairs Manual, which is the authority for the Department of State. So those are pretty much the area of laws that we work within. Like to understand the agencies. I like to call this a family tree. So you see everybody that's involved. You have the Department of Homeland Security that was created post 9/11, and they've created Customs and Border Protection. Those are the folks you see at the airport and at the borders when you come to enter the United States. You have the U.S. Citizenship and Immigration Service. They are the ones that adjudicate cases, also do green card interviews at your local immigration offices. Here in New York City, it's Federal Plaza. Then you have Immigration, Customs and Enforcement that you may also see at borders. They may also be at the airports. They also oversee the student visa process. Then I spoke about the service centers, and part of that also comes under I-9 and E-Verify, which is employment eligibility and employment verification. And then we have the Department of State that also, they oversee J1 visas, research scholars and clinical J1s, and they also constitute of U.S. embassies and consulates. They release a visa bulletin about the number of green cards available every year, which we'll talk about later. They also adjudicate J waivers in certain circumstances. And another thing that's often relates to, can confuse people sometimes, is visa versus status. You may have somebody calling you for employers out there, you may have an employee that calls says, oh my God, I'm out of status, because the visa and their passport has expired. And not to worry, that visa is really like a key that facilitates your entry to the United States. And that's issued to you by the US consulate abroad. That lets you enter America. If it expires while you're in America, it's okay because you're still in status, because your status is determined by something called an I-94 arrival departure card. And that's what's going to allow you to stay for a period of time. So when you enter the United States, present your visa, the Customs and Border Patrol person will say, okay, you're authorized to stay for X amount of time. If you're on an H-1 visa, it may be for 3 years. And that's what's going to decide how long you're authorized to stay in the United States. So status versus visa are two different concepts, very important. I'll hand it over to Cora-Ann.
Thanks, Hamel. So having gotten this little overview of the players in the immigration process, we wanted to also provide a brief overview of the various non-immigrant visa statuses that one could hold for employment-based in order to work in the US. So we'll start off with, we did have a PowerPoint that runs through a few of them. We're not going to be able to touch on every single one. We'll start off with the H-1B visa, which is the most popular visa that everyone has heard of. And the H-1B visa an H-1B petition is filed by a US employer, not by an individual, must be an employer with a federal employer identification number. It's filed with USCIS on the Homeland Security. It has to be filed with Homeland Security. It's not the type of visa that one can just apply for abroad at a consulate or an embassy. It's filed in the US, and the employer has to demonstrate that they're offering a professional position to the foreign national. The position is classified as a specialty occupation. A specialty occupation is one that requires a minimum of a bachelor's degree for performance of the job duties. So in order to get an H-1B petition approved, the employer has to show that they're offering this professional position. It is a specialty occupation, and the foreign national possesses the relevant degree. The foreign national cannot possess a degree in anything. It has to be a degree that's related to the occupation. So if the foreign national has a degree in political science, that foreign national will be unable to get approval for an H-1B for an IT position, let's say. It has to be related. Then most of us have heard about the fact that the H-1B is subject to a lottery. That's the biggest sticking point of the H-1B. In order for a foreign national to enter into the H-1B system process, get an H-1B, they first have to be selected in the lottery. Every year, every fiscal year, the government has 85,000 H-1Bs available for grabs, just 85,000. 65,000 are earmarked for those foreign nationals who possess bachelor's degrees. And you can possess a bachelor's degree through academics or based on a combination of academics and experience, or just all experience. 3 years of work experience equates to 1 year of college. So if you have 12 years of experience, professional experience, that could equate to an equivalent of a bachelor's degree. So every year, they started this a few years ago, every year they started this registration process where the employer will identify individuals that they wish to employ in H-1B status, enter their name in March during a period that the government designates, usually March 1 to 18, something around there. Enter these names into the system, the person's name, their passport number, their male, female, what have you. The period closes, the government runs the lottery. They pluck 60,000 names from the entries, and those are the individuals who are going to get selected. Then after that, there's a drop down, they pluck 20,000 more, and these 20,000 is earmarked for individuals who've earned a master's or higher in the United States. So altogether, we have 65 plus 20, 85,000. The problem with this recently is that more and more registrants are being entered into the system. So this year, for March, they had 781,000 registrants for 85,000 slots. So it's really like traumatizing, even for me as an immigration attorney, having to enter all these registrations and then having to sit there and tell everybody that they didn't get selected. Even if you try to manage expectations and let them know that this is a small chance, but when you actually have to sit there and let them know that, it's not the best. And I think the problem is, and panelists can chime in, I think the problem is that each employer has to enter the foreign national's name, can only enter it one time. So they can only apply for Yana one entry. The employer cannot say, I'm gonna fill up the lottery with 10 entries for the one person I like, or I want. No, they can only enter it one time. But every employer could enter this person's name. And what I've seen happening, I don't know if you guys have seen it, is there are agents cropping up who, if I'm a foreign national and I'm graduating, I can contact somebody who's in touch with 50 employers. And that person can get my name into each of their mouths, and they can each enter my name. There's 50 different employers, and whoever gets picked for the lottery for me, I go there, because I don't care where I go. I just want an H-1B. And the beauty of the H-1B visa is that it allows for portability, which means that once you have it under a particular employer, another employer can sponsor you, file in a new H-1B, and you move on over there. So it's a very flexible visa. It's actually one of the best visas. That's one form of flexibility. It's also a visa of dual intent, which allows the foreign national to say, I want to be a non-immigrant coming in for this particular purpose, but I also want to maintain a future intent to be an immigrant and live here forever. Other visas don't allow that. Most of the other visas don't allow that. So it's a really good visa for that purpose.
I did want to also mention there is a CAP exempt category for H's. So if you are an institution of higher learning or not for profit, you do not fall within that lottery. So there's certain employers that don't have to worry about that. And you're allowed to apply for an H-1 all year round. If you do go from a CAP exempt employer to a CAP subject employer, you are then subject to the lottery. So that you can't just transfer that H-1 from CAP exempt to CAP subject.
Exactly. Another thing about the H-1B is there's something called a labor condition application, to which the H-1B employee is basically tethered like a dog to a leash, really. I like to think of it. Where the H-1B goes, this application must go. It's an application that's filed with the Department of Labor, indicating the wage that the individual is being paid and the location that they're going to work at. And this has to be consistent throughout the duration of the individual's H-1B. So the minute that an H-1B is being moved to another location, a new LCA will need to be filed. So in the pandemic, this was a huge issue because suddenly we have workers working in Manhattan, working wherever, and then suddenly we're on lockdown or stuff's happening. The H-1B says, I want to go home to my family in Seattle. I want to just stay low there and I work from home. And they fly out to Seattle and the employer doesn't know that, well, Seattle is not within commuting distance of the location originally indicated when they filed the H-1B. Whenever an H-1B moves out of the commuting distance area, which is a distance about like 50 miles around the area that you said, a new H-1B petition must be filed to amend the existing H-1B to allow the person to move to the new location. So not knowing things like that could really cause the individual to not maintain status and cause problems down the road. Another thing with the H-1B, they're subject to site visits, which we'll talk about later, where an officer could show up at the site and the H-1B is not there. The receptionist doesn't know the person's name. They're like, who are you talking about? We've never heard of this guy. This can open a whole bunch of issues for the foreign national. And, you know, the fraud department is looking for misrepresentation and fraud. And, you know, if that gets pegged to the attached to the employer, this could have really rough repercussions, not only for the employer, but for the H-1B, in something that I find to be really unfair. If an employer is found to have committed some type of fraud and misrepresentation, the H-1B that was granted to the foreign national is snatched away from him. And even if he didn't know what was said in the H-1B petition, because this is an employer's petition, he has no control over what they're saying in this petition. And the employer doesn't have to give them a copy or anything. And I recently, you know, had a client who just had no idea, and he has emails where he said, can I get copies? And they never gave it to him. Turns out what they said in the petition is not what he was told. And the employer got pegged for fraud. His H-1B got revoked. He's had to fall out of status. There's nothing he could do. It's really important that, you know, foreign nationals advocate for themselves, make sure they know what's going on, and that employers know the repercussions of their actions.
But Cora-Ann, can I interrupt you? So what happens in that scenario? If you fall out of status for whatever reason, do you have to leave the country immediately, or what's?
You do have to leave the country immediately, and we're going to talk about grace periods and what happens if somebody's terminated or they fall out or the H-1B gets cut, whether they enter a grace
You
period or
can
not.
also file for a change of status to maintain your status to visitor status. And employers should be giving employees a copy of the petition that was submitted on their behalf, because when they apply
Should,
for a visa at the US consulate, they need that information to be able to return to the country.
And can someone on an H-1 then, once their employment is terminated or something happened fraudulently and the H-1 is revoked, can they apply for unemployment benefits? Or are they entitled to those type of?
That's a whole other panel. Because while they do pay into Social Security, you know, you have to be ready, willing, and able according to the terms of the labor condition application. And if you're ready, willing, and able, but the position's not available to you, you're not going to be eligible for unemployment. It's a great question.
Yeah, it's a pretty rough situation, but yeah, if they can file a change of status as quickly as possible, then that buys them some time to wrap up and leave the country. But of course, everybody wants to work and be employed, and the status is available, like she said, visitor status, or if they have a spouse who's in another worker status like L, they could file for a dependent H4 or an L2, which has the employment authorization. But a lot of people don't have these options, and they unfortunately have to leave the country.
So just to piggyback on that, so we're hearing about all these layoffs in the tech sector recently, and most of them they say they have the H-1B visa, and because they're professionals and they have degrees, and so once they're laid off, technically they're not eligible for unemployment. Is that unemployment? I mean, benefits, and do they have to leave the country immediately or face deportation?
Well, we do have a section coming up on all of that, and they do enter a grace period. They're not they're not out of status right away.
Right, correct.
There's a grace period.
You have a grace period of time, so you have 60 days, depending on the termination, to find another employer. And deportation is you know, the deportation is such an extreme word. You get deported if you've committed something in violation of your immigration status, so that's not immediate. So it doesn't, in situations like this with a grace period, you're typically protected. An H-1 worker is always going to seek out wise counsel and make sure that they're secure.
Yeah, there are ways to work around it. Of course, you have the official grace period, but even beyond that, as long as when you're out of status, you don't go 180 days past the date that you fall out of status, because you have to be aware of what's called a 3 or a 10-year bar. If you've overstayed for more than 180 days past the time that you were cut off, potentially you could be subject to a 3-year bar if you ever leave and try to come back. If you've overstayed for a year, 10-year bar, you leave and you find out, oh, I've overstayed for a year and now I'm subject to a 10-year bar, I can't get back in. So there's different things that have to be considered, and immediately if somebody gets terminated, you need to call an immigration attorney immediately to try to figure that out. So yeah, that's the H-1B. Dependents have H-4, and H-4 can come with local authorization in some respects. when the H-1B principal has a green card petition that was approved on their behalf, but they're subject to backlogs like Indians or Chinese, potentially their spouse could get work authorization based on the fact that they are backlogged and they just can't get their H-1B.
Are dependents
green
only
card.
spouses or can
Children,
and children?
yes, until 21. Anyone under
Under
21 is a child. Once you're over 21, what they end up doing is switching to student status or, trying to go to school as an F1 student or find some other, but they can no longer be H4.
Right, and if they have a green card that's been approved, depending on when it was filed, there's something called the Child Status Protection Act that might grandfather the child in and protect them to allow them to remain in the country until that green card's given. But it depends on when that petition was filed.
We have a bunch of other slides here that we included more slides than we can talk about in the time, just so that people can have something to look to, like how to have an equivalent degree and different issues like how the employer knows, when they file an H-1B, they have to classify the position under an occupational classification. That's an important decision as to what occupation you're going to say this is, because that occupation lets you know what the government expects to see. Do they expect you to say bachelor's degree? Do they expect to say, if you say computer systems analyst, there was a time when they pushed back and said that these people don't really have to have a bachelor's degree. So there was a lot of pushback. So what you pick is really important. So we have a slide on that. You have a question?
Before you transfer, I just transition. So question for the audience, are there any bars for countries or regions in the world for the H-1B visa?
No, there are no bars. Any foreign national, what you need is an employer to sponsor, put the name into the registration, register the name in the lottery, you get picked, they file the H-1B petition by the deadline indicated, and they come in. There's no bar as far as nationality.
Right. However, there is, there's export controls. So if you're an employer that has export control issues, you may need to provide a technology control plan for people from certain countries of certain origins, to make sure that the technology that's being used by that employer is not going to be subject to export controls. So you may have heard a lot of things about ITAR and EAR, where you want to make sure that foreign nationals coming in aren't going to be using technology that's in America and taking it back to their home country to be used against America. So that it's not a bar, but there's an extra step that's involved.
Does the State Department have a list of countries?
There are a list of countries that are listed under the Bureau of Commerce. Iran, Sudan, Cuba, North Korea. I'm forgetting, there's one more, but there's right now, those are the countries that may be subject to an extra control license requirement, depending upon if the technology that's being used, depending on what the position is.
Okay. So just to run through a couple of the other non-immigrant visas, that common ones. We have the H-1B1, which is the H-1B essentially, but for people from Chile and Singapore, they have their own carve out where they don't have to have the petition filed with Homeland Security. They can apply at the consulate in Chile or Singapore. It's essentially the same type of argument and everything, but they're not subject to the 65,000 or the 20,000. They have their own number, which I've never seen it be reached. They've never had enough that it's maxed out. So if you have a client from Chile or Singapore, great, there's that. You have I've seen like two. So the E3 is another carve out for Australians. If an individual is from Australia, they have the E3. It's like the H-1B, but for Australians. They get to go to the US Embassy in Australia with a nice letter from the employer describing the position. They do have a labor condition application setting forth where they will work and how much they'll be paid. And they can only get it for 2 years at a time. But I mean, that's the least of the worries. They're not subject to the lottery and it's always there for them to obtain. The TN is another carve out for Canadians and Mexicans. The TN though, unlike the E3 and the H-1B1 and the H-1B, where it's a professional position and you just classify it under an occupational classification, the TN comes with a finite list of classifications. They have a very specific list and the job must fit into one of these classifications. I can't think of a job that doesn't off the top of my head. If you can think of one, what doesn't fit on the list?
A clinical physician.
Okay, so there are some jobs that are not, it doesn't appear on the list. For someone like that, cannot file a TN for them. But if it fits under the list, they have computer systems analyst, lawyer, engineer. If it can fit there, the employer can file a TN on their behalf for Canadian or Mexican. There's no limit. They can keep getting TN forever
In 3-year increments.
in 3-year increments. We have the E1, E2. I'll leave that slide for your information. That's just like an investor or trader visa. And you have the L1, another popular visa for transferring individuals who've been employed at an affiliated entity abroad for over 12 months, at least 12 months, in a managerial, executive, or specialized knowledge position. They can be transferred to work for the US entity, the affiliated US entity, in another managerial, executive, or specialized knowledge position. So that's really good if you have global clients who have companies around the world. This is a really good visa because there's no cap, there's no, not cap, there's no lottery. There's a cap, it's a 7-year visa, but there's no lottery and you can get it at any time. It is a dual intent visa, just like the H-1B. So it's a pretty, one of the next popular visa, I think, after H-1B in my mind. Then you have the O and the P, just to wrap up on the summary here. The O visa is for extraordinary ability individuals. If someone is extraordinary in their field, they're a great dancer, they've won all these awards, they've been on Dancing with the Stars, perfect. You can just file an O1 visa for them, describe, there's specific categories there that they have to hit. They've been in a leading role in the dance troupe, they've won awards, they've been talked about in this here magazine, or we have all these pictures, we have everywhere they've competed. There are certain criteria that they have to hit, and if they can, O1 visa.
And it's also applicable to scientists and researchers and physicians. You got to show that you've sustained national or international claim in what you're, I'm sorry, international claim in what you're doing. And multiple citations, publications that you're considered to be extraordinary by your peers. So that's also another O1 option.
So, okay, so let's, for time, we're going to wrap up on the non-immigrant visas and switch to employment-based immigrant visas. So the immigrant visa is the green card. So that was all non-immigrant. You get a visa, you come for a specific time, you extend your visa, all of that. But we also have the immigrant aspect where the employer can sponsor you to get a green card. And how does that work? So we have three employment, we have a few employment-based immigrant visa categories. You may have heard of EB1, EB2, EB3. The first category is for individuals of extraordinary ability, more like the ones who got the O. You can do that on the non-immigrant level and on the green card level. On the green card level, they obviously scrutinize it some more to make sure you're really, really extraordinary and you're going to be able to get a green card on that basis. But the more popular way is to get it through the EB2 or EB3, which is through a labor certification. So most times the employer would find that the worker is really great, who has been here on H-1B or L-1B or what have you, and they want to sponsor them. The first thing they have to do is file a labor certification application with the Department of Labor. And that application process is one where the employer is testing the labor market to identify any qualified, willing, and able US workers who are there to do the job that's being advertised. And only if the employer cannot find any qualified, willing, and able US workers, then they're able to say, well, we did this test, we have no one, we have to give this job to this individual. So with this, there are different things that come up. From right now, a hot button issue is the wage transparency law, where the employer has to now advertise, New York is subject to that. Well, New York City and New York State right now, right? Yeah, subject to the wage transparency, where when they advertise, they have to indicate what is the wage that's being offered to the foreign national or for the position, not to the foreign national, but what's the wage being offered for the position. And how that's affecting immigration is that part of this process is that the employer must ask the Department of Labor, what is the wage, the minimum wage that I must pay to someone in this position? That process of them asking for the wage is currently at 7 to 9 months. You file an application, it takes the Department of Labor 7 to 9 months right now, some even a year waiting. So that's another thing. 7 to 9 months generally to tell you the wage for this position is X, but you have to advertise this. So now you're waiting 7 to 9 months, you get the wage, then you have to advertise. Prior to them, through wage transparency laws, the employer could just start advertising right away and be ready with the ads, ready to go. Once they get the wage back, file, but now they have to wait for the wage, then advertise because of this wage transparency. So that's one thing. So they go through all the resumes, they check, make sure that no one has the degree that they asked for, the experience they indicated, if nobody, they interview if necessary, and they have to be lawfully rejected, these applicants. You can't just reject an applicant for, you know, he was unkempt, or he spoke too fast, or he had his head down, or whatever, or he didn't reply quickly enough to my email. None of these things. It has to be strictly black and white. Did they or did they not have the qualifications you asked for? Should they not find an applicant, they can move to they'll file the labor certification, hopefully it gets approved, and they move to file a Form I-140 petition, which is actually the immigrant petition that's filed with Homeland Security, USCIS, where they say, I did everything, I got a certified application, and now I have to offer this position to my worker here who's a foreign national in H-1B. He has everything I wanted, the degree, the experience. Here's his resume, here's his job letter, employment verification letter, here is his degree, and that could get approved. And the final phase in the green card process, if that's approved, is moving to file for adjustment of status, which is moving from whatever non-immigrant visa the foreign national holds to lawful permanent residence. This whole process takes more than 2 years at this point, just from start to finish.
Cora-Ann,
yes.
for clarification, for people who aren't familiar, when the employer files or advertises, how do they advertise if the person they are sponsoring or trying to sponsor is already on their payroll?
Right. So basically what it is an offer of permanent employment. If someone is on their payroll in some other non-immigrant status, that's a temporary job. So, you know, it's not a permanent position because you're here in a finite visa. It's not a permanent position. So let's say the person's here and they're a software developer. They like them. They want to offer the position of the software developer permanently. They advertise for this position and they have to indicate what are the requirements for this position, what degree, what experience. They have to make sure that what is indicated is not on the job experience that this person learned while they were working there. So the person came into the software developer position with 1 year of experience. And after working for 4 years and now having 5 altogether, the employer likes them. The employer cannot say that this position now requires 5 years. It has to require 1 because they were good enough to come into it when they had 1. So that's what we have to stick to. So then they advertise for that software developer bachelor's degree plus 1 year. That's what they advertise for. And if nobody has that, then they move to all the different phases that I mentioned. So yeah, and then as far as layoffs, we just want to mention that layoffs in this respect can be a bit of a problem. You know, whenever the employees are petitioning for foreign national for the green card and going for this whole advertising and labor certification, if there's a layoff in the area where the individual is supposed to work, and the employer is obligated to contact these layoffs if they feel that these people are potentially qualified for this position. So they laid off a bunch of software developers and now they're advertising for a software developer position. And they know that 10 of the people laid off potentially have everything that they said they need. They have to contact these layoffs and say, this is the position. Would you like to apply for this? Are you interested? And do that evaluation. So that's, and if they cannot, then if they don't want to do that or whatever the case, they cannot file the labor certification on behalf of the foreign national. So with that, I think I might be at time. So we'll move on to layoffs. And we had some questions on layoffs. We wanted to discuss more about.
Yeah, before we move on, I should announce the
US site visits.
I should announce the CLE code for those of us joining us on Zoom, which is EBG-255. It's EBG-255. So those of you on Zoom should write that code down and put it in your affirmation form. And so
Yeah, the next time will be US site visits.
So we mentioned earlier US site visits. So this basically is created to combat fraud, and it started in 2017, where the government will show up at your place of work and say, hi, we'd like to see so-and-so, and we want to speak to this person, and they want to when they do speak to the employee, they want to see their pay stubs, they want to see where they're working. They'll ask them, what's your degree? Did you pay for the filing fees associated with this process? Because the filing fees for an H1, the employer has to pay. It's regulated that employer must pay. They will actually sometimes ask to see the copy of the degrees, and they'll walk around your place of employment. It's important as an employer for you to notify the receptionist at the front desk to let security know, hey, immigration might appear for a site visit. And they're random. They're actually done by postal code, zip code, when they run the report. So if your client is the only H1 employer, on the Upper West Side, that they may receive a lot of site visits. They are, for the most part, friendly visits. They come, they're courteous. Normally it's best to have a conference room set aside, let the officer do their job, let them speak to the employee. And if they'll go back and show their findings to the fraud unit. And if they do think that there's something surreptitious happening, they'll make a recommendation that this should be further investigated. Worst case scenario, they may revoke that visa. The employer may be prohibited from filing H1s, suspended from filing H1s in the future. So it's important to be consistent, especially in this day and age of hybrid and people moving about in different parts of the country, to make sure the visas are updated and the government is notified at all times, like this person no longer works here, this is their place of work now. If they're working from home, you may have to post a notice in this person's home that they're now working here to satisfy the regulatory requirement, where we've had people take pictures of the site, the posting on their refrigerator to show that wherever that they've actually been working, so you can satisfy the regulatory requirement to show that they're now working at a different site. Right now, during COVID, they were doing things via email. A lot of it was suspended. They're moving it towards more of an email type of site too, where they'll do it by Zoom or something to just make it a little bit more streamlined.
These site visits also occur in the L1 visa context.
Yes.
They don't occur in the TN, the E3, the H1B1. No, yeah,
Those
the
two.
O, yeah, the H1B1. Any H1B, any L, but not in the TN and the E3 and the O and the P. Those are exempt.
Right. And termination. So this is one thing that had come up, that when you petition for anybody to come work here, you're making an obligation to the government saying, once they've finished their term, we will ensure that they'll return back home if we terminate them. And that applies to the H1 and the E3 and the O1, because they want to make sure that the person goes back. And that's if you terminate the person. That requires a one-way economy class ticket. It's for the person, not their family members. And there's you have to notify to the government that you wish to withdraw the petition because they're no longer in your employment. And it's really important that you do that, because if you don't, you may be responsible for back wages. So you want to make sure that you've notified the government, this person doesn't work here anymore, we're withdrawing our petition. Now, going to grace periods, to your question, how much time do they have? And I see a typo for E3, it should be 2 years indefinitely. I don't know why it says 7, so excuse me for that. And there's a period of time they can come in 10 days before they start. They can come in 10 days before they start. If you're an H1 and you're terminated, you have a grace period of 60 days to allow you to find new employment, which is very welcomed, because if somebody's here, imagine trying to wrap up your life in 2 days. And that works out very well in an environment where there's some sort of uncertainty, to allow someone to really be able to make a good faith effort to find another position, or ultimately go back home, and the employer will pay for their return home transportation.
Mike, can I interrupt you one second? So what if you're terminated by your employer, you're a H1B visa, and you happen to be in part of a union as well, part of a collective bargaining agreement, which has a just cause provision for termination, and your union grieves it on your behalf, and you're waiting for your arbitration. How does that work with grace periods?
Excellent question. So when you're in a union and you've been terminated, there's a CBA, right? You have the grievance period. You can, depending on the employer, you can put them on an unpaid leave. That you can give them, to allow them to go through that grievance process. And if the grievance is like, okay, give them back their job back, then no foul, no harm, because the age has not been withdrawn, because you're in that gray period where it's being contested, right? In terms of, are they going to be really terminated, or is their job going to be secured? So in that instance, the employer normally kind of holds off on withdrawing that, because you're terminated, but not really terminated until final decision is made through the grievance.
Does the employer have to notify the government at the time of the termination or after the whole?
I would say during a grievance time, it's not a final decision. So you can hold off, and you don't want the grievance to, it's not going to last a year, right? You want to expedite that, but you want to make sure. Well, depending on the ground, what are the grounds of termination is also, is there criminal activity involved? I think that also drives which direction you're going to be going in. What's your?
Yeah, I agree.
stance?
I mean, I would not advise the employer to notify them that you're putting them on this gray area. It's the same thing for like garden leave. When there's a non-compete and H-1B is being let go, but there's a non-compete, he literally cannot go to the competitor and take up that new job. So there's a gap. The employer understands that we're going to keep paying him his full salary, keep him employed, but he's technically not employed. But I mean, we don't have to notify, that, hey, he's going on garden leave. No, whenever it's cut, then they withdraw the petition.
And can I just follow up on that? What is the incentive for the employer to do that? Why would they go ahead and put somebody on an unpaid leave, or go ahead and give them wages during the period of time that they're still obliged to non-compete, rather than just say, well, we're terminating and inform the government.
You actually could do that. I think that comes in where the employer wants to do the right thing,
Yeah, gotcha.
and do right by the employee in those circumstances.
It's not a mandatory. Okay.
In your experience, how common is it for employers to behave in the way you described it? In terms of, being favorable and working with the worker?
Unless something completely egregious and criminal has occurred, most employers really want to work it out and balance it out, especially when there are immigration issues involved. And because the foreign national more than likely has family members attached to them. So there's always looking for a balance where you can. That's what I've seen.
Also, the employer is trying to avoid some type of investigation as well. I mean, the foreign national can also file a complaint saying, unfair practices, this and the other. Next thing you know, Department of Labor is coming on their premises demanding to see all sorts of paperwork. I mean, who needs that? So, it's beneficial to the employer as well. So let's work together, figure this out.
And just to follow up on the distinction between terminating and a person quitting prior to the end of the time that their visa runs out. What are the employer obligations in that?
Well, New York City is at will, right?
Mhm.
So if you resign, it's like you're leaving us, right?
Right.
So we're withdrawing the petition that we filed on you because you're resigned. And more than likely, when someone resigns, that means they're going to a new employer. So they're going to be transferring their H-1 to that new employer.
Mhm.
So it's a happy goodbye, in that sense.
I guess, and you may be covering this next, but besides terminations, I was thinking about layoffs, because we're watching in the news lots of layoffs happening, impacting tech industry. I don't know if that was a topic you were
Treated the
going
same
to.
as a termination.
Okay.
Layoff, termination, you're gone, either way. So again, you get the same grace period. You can go look for another job within the 60 days. Once you find that new employer willing to sponsor you, the minute the employer files the petition, you can start work there. You don't have to wait for it to be approved. You can go right away.
You have to have the receipt.
Yeah, it has to
Proof of
be filed within this. It can get there on the 59th day. And once you get the receipt, then start working.
So I guess my follow-up to that is like, what are the implications in this climate where these companies are having these mass layoffs? And the implications, in my view, are that there are lots of people on these H-1Bs and special visas who are being laid off. like what are concerns? Are immigration lawyers more busy than ever addressing, this changing market and climate in the tech industry and other industries?
I mean, I think it depends on your clientele. I mean, I used to work at a firm that had heavy IT based, so they had to have all these calls about these layoffs, all departments, this being shut down, that. So we have to sit and have, plan it out. Like, when are you planning to do this? What are the effects on green cards? What are the effects on visas? What's going to happen? So it just, as far as immigration lawyers and more work, it would only depend on the clients that you have.
Right. And an employer would also have done their due diligence to say, okay, these are the employees that are on visas. These are employees that have pending green cards. What are the implications to them? What are the implications to the employer? And, a good employer would more than likely take that into consideration because there's been time invested on both sides. And the sooner it's going to happen, they may do things to help accommodate them to move to a different space. And it might be like, listen, we've done everything we can, but we're going to have to let you go. And here's what you can do next. And sometimes that employee will have to consult with their own private counsel because the employer is wearing the employer hat. The private counsel is going to be counseling them in the interest of the foreign national.
Before we get to the next portion of the presentation, which is temporary protected status and DACA. Back to this layoff situation, say you're laid off, because you mentioned it a bit about, I think you mentioned a recall. There's layoff and recall sometimes, say you're senior and how does that recall part of it affect your status and your rights under the CBA? That's
Recall.
meaning, so you're laid off, you have a grace period. If I think you had mentioned earlier that if then the employer then asks you to return, that the employee, the person has to take that, whatever the position offered is, or how does that work?
Well, when you're talking about layoffs.
Yeah, I mean, it would be the same position. I mean, so you're in a software developer position or whatever the position is, and there's this gap because of whatever's going on. You come back, that's the same position. I mean, it's not like they can't offer you, we're tethered, like I said, to the labor condition application, whatever was indicated, that's the position you're coming back into. Should there be another position, something else will have to be filed, an amendment, a new petition. But when you recall, you come back into the same position. And presumably you've been
So
earning
you
your
couldn't be
salary.
recalled into a different.
No. The H-1B, one of the things to remember is any material change to the existing petition requires an amendment. And a material change is a massive change in the job duties, not like a slight little promotion, but like a big change. If they're going to downgrade your hours from full-time to part-time, that's considered a big change because you're decreasing the person's salary. The government wants to know what's going on. And again, moving people out of the commuting distance from where you indicated. So those kind of big changes, a new position would require an amendment.
Okay.
So
Let's move on. I think.
Oh, I'll just ask one more variation on that, which is that many collective bargaining agreements have recall provisions that can last quite a while, say 6 months or longer. If the position that the person is in from which the person got laid off, the worker got laid off, is tied to a visa that runs out before that the recall rights expire under the CBA. Is there any way that the CBA helps in that person getting
Federal law
Yeah.
will prevail.
Okay, so why don't we go to the next slide? Okay, which is very short. But here's the main point of this. In addition to being able to receive work authorization through a non-immigrant visa, and in addition to being able to receive work authorization through an employer sponsorship to get a green card, there are also other categories of immigrants or non-native born people in the United States who can get work authorization. And two of the big categories are these: temporary protected status and deferred action for childhood arrivals. So what is temporary protected status? The temporary protected status was created in 1990 for humanitarian reasons. And it was an act of Congress that put TPS into the Immigration and Nationality Act to recognize that
there are people in the United States who can't return to their home countries for various reasons because the home country is in such disarray. So they put this in the INA. It's renewable. It empowers the Secretary of the Homeland Security to designate countries for TPS. And all of the power of designation really does sit with the Secretary of Homeland Security. A lot of people think it sits with Congress, and it doesn't. It sits with the Secretary. The Secretary both gets to decide what countries will be on the list for TPS and which countries will be renewed, which are generally, it's a 2-year designation subject to renewal. Is that correct? 2 years? Currently, there are 16 countries on the TPS list: Afghanistan, Burma or Myanmar, Cameroon, El Salvador, Ethiopia, Haiti, Honduras, Nepal, Nicaragua, Somalia, South Sudan, Syria, Ukraine, Venezuela, and Yemen. And these are all on the list either because the political situation in those countries is such that it makes returning dangerous for people who are here in the United States, or because they've had, such as in the case of Haiti, natural disasters that make the conditions, the economic conditions and infrastructure conditions in those home countries sufficiently bad that it's difficult for the people here in the United States to return to those countries. So how it works is, if somebody is from one of these designated countries and is in the United States and has been residing for the period of time that is designated by the Secretary, they can apply for temporary protected status. There are some conditions, in addition to having to been here, have had a continuous presence for a certain amount of years and been in the country in the right period of time. They also, can't have things like criminal backgrounds or other things that would disqualify them from being able to get this grant. But then once they get it, if the country gets a renewed authorization, they can then continue to reside under TPS with those, they have to go through renewal processes, both for renewing their TPS status as well as renewing their employment authorization, but they can continue to stay. Oftentimes, during the period of time that TPS recipients have TPS, they may marry or other conditions may change that may qualify them for other sorts of visas. And that happens as well, or they have citizen children. Some of these designations have been in place for a very long time, so the citizen children have come of age and can then sponsor them. So there are various ways that somebody can move out of the TPS status onto either an immigrant visa or potentially into some path towards green card and ultimately citizenship. The thing for many, both employers and employees, to keep in mind right now is that the TPS in general was challenged under the Trump administration, and there are specific countries that were protected through a court stay when it was challenged, so that these countries, even though the administration was trying to argue that they were improperly granted TPS or that the TPS shouldn't be renewed, through the court proceedings, the TPS status of these countries has been continued. And those countries, or 6 of them, include El Salvador, Honduras, Nepal, Nicaragua, the 2011 Haiti designation, because there's more than one designation, and the 2013 Sudan designation. And the reason that this is important is because many of the workers that are from these countries and have TPS will have documents that appear to be on their face expired. But these are documents that function for work authorization and that the employer is obliged to accept as proof of both work authorization. And so it's important for both employees and employers to be aware of this so that they aren't rejecting documents that they're obliged to accept in satisfaction of the I-9, which we're going to talk about in just a minute. In addition to TPS, there is what probably a lot of you have heard of, which is the Deferred Action for Childhood Arrivals, also known as DACA. And DACA is a deferred action program that was a very large deferred action program that under the Obama administration was formalized and applies to a very large number of people. So deferred action is exactly what it sounds like. It's deferring prosecutorial action against people who could be removed from the United States. Under the Obama administration, the administration said we're exercising our authority to not remove and take action against these people who qualify, which were people who had come to the United States as young children, lived in the United States for a long time, and who were coming of age, who were becoming adults. So there are various qualifications. You have to have been in the United States during the right time. You have to be of a certain age, within a certain age bracket to qualify for DACA. But once, if you do fit into those categories and there are no negative equities against you, again, there's no criminal issues on your record or no other reason why the government shouldn't take action against this person, they can get deferred action, and with that comes work authorization. And in certain industries, there are quite a number of younger workers who have deferred action as part of their status to stay in the United States.
Just one of the follow-ups. By work authorization, what do you mean? They get a card of some kind? Or?
Yeah, most people have what's called an employment authorization document, and it does look like a little card, and it will have their category of how they got that card.
Looks like a little license.
Yeah.
There's their picture on it.
Yeah.
Which is a great segue to the I-9.
Yeah.
So the Form I-9 is, it came into effect November 6, 1986. And it's used to identify a person's identity and work eligibility in the United States. And it applies to anybody that works in the United States. And employers, it's for somebody that's going to be working here. And there's certain rules that apply to it where you have to complete the document. There's two sections on the form, Section 1 and Section 2. The employee has to complete Section 1 once the offer has been accepted. And Section 2 has to be completed within 3 business days or 3 days after the offers, after their date of hire. So if you start on a Monday, Section 2 has to be completed by Thursday. Now, if you are a federal contractor, you have to enroll in E-Verify, which is an electronic system. So there's 2 pieces. You complete the I-9, which is an electronic I-9, and then you submit that I-9 information to E-Verify, and it will verify that this person is authorized to work in the United States. And the documents that Ingrid had mentioned, the employment authorization, the employer has, there's lists. There's list A or list B and C. So list A will allow for identity and employment eligibility, and list B will identify eligibility. Identity, and list C will identify eligibility. So there's all of those together will allow the person to work. There's some people that do paper I-9s. Some employers, I think most employers now have moved to an electronic system. You can, as an employer, decide to keep copies of the documents that are provided or attach it to the I-9 if it's paper, and if it's E-Verify, it's all scanned and submitted, and it's held in the cloud, if you will. And there's some exceptions if they're volunteering or interns. They don't need to complete the I-9. It's remuneration for getting money for services performed. Here's the, I know that we're running on time. So the other piece here is the responsibilities. It's really important. It's one form. but you can run into a lot of fines and penalties for discrimination. These are excellent resources here. There's a quiz you can take. The Department of Justice has a great training program. You cannot use these systems to vet people to say, oh, let me put in the person's name or their information and see if they're actually allowed or authorized to work in the United States. Which these are the acceptable documents, which I'm gonna go. There's a whole handbook that's available called the M274. The link is in the handout that explains everything that an employer must do, employer obligations, employee obligations, and the fines and penalties. So if there's a pattern in practice where an employer is asking anybody with, that has a certain ethnicity, show me your papers, or, you can't do that. I'm gonna hand it over to Ingrid.
Well,
to talk
I mean,
about that.
that's a lot of, you've gotten to, I think the main point, which is that employers can do an internal audit and re-verify. They cannot do that in a discriminatory manner, certainly cannot do it, in response to workers starting an organizing campaign, for example, to try to form a union. That would be another practice as well as other things. And obviously, if somebody has documents that need to be re-verified because they're going to expire, they are not only entitled, they're required to do that. But employers cannot undertake to discriminatorily in any way use the re-verification process to discriminate. And this, they can't engage in unfair documentary practices during the e-verification process, which means, like you were just explaining, the mandatory mandating certain types of documents. And sometimes actually employers will do this without realizing that they're doing it. For example, somebody may have, for the first time that they filled out the I-9, had a social security card and a driver's license. And so the employer, when it comes to re-verify, asks for your new social security, or let's say the social security card had an expiration date on it. Or let me use the EAD, because an EAD expires very often. So they ask for a new EAD. Well, if the employee has somehow changed status and now has a green card, they will have a social security number, so they can provide that. Asking for the specific document is not something that the employer should be doing. They should ask for the documents that are on the list, and any of the ones that satisfy the list are acceptable. Asking for more documentation than what is required on the list is also a discriminatory practice. Yes.
So it gets a little tricky and from the employer, because a lot of times the employees call and contact you and, I have this, but I don't have that. And I have this and so you get into a really tricky position.
Right.
And this came up recently for me, because you don't want to tell them, this is what you should do, then use this.
Right.
And, get yourself in a situation where you're telling them what to produce, because sometimes they lose documents, so how do you handle and navigate
you advise
that?
on this every day.
I always say, here's the list of documents, either list A or B and C, you pick. Because that's what you're supposed to do.
Yeah.
And that makes it a lot easy for the person. And they may be like, you're not helping me. You're like, I am. You can pick from list A or list B and C.
Yeah.
And go through the list and pick whichever documents that you would like to present. And I would also provide, here's the link where there's a link on USCIS as well as Department of Justice that employees can look at to see and understand what is required, so they can educate themselves and understand what they can present.
And the USCIS website has examples of documents, and that sometimes is helpful for employees as well.
Yeah.
Pictures of what it looks like.
Yeah. And I will say, for anybody who's, on here, who's a employee or union advocate, the same thing, reiterating to the workers themselves that, if they have those kinds of questions, it's not really appropriate to ask the lawyer for the employer about that, or the HR person, that they should, they can seek help from the union, or they can seek their own counsel. But, also reiterating that they can choose any of the documents. In addition to the documentation issue, the process of verification and re-verification can't be a platform for citizenship or immigration status discrimination. So, for example, it would be unlawful for an employer to say, there are a few exceptions, but employer to say, we're only going to take citizens, only citizens need apply. Or we only want green card holders because we don't want to have to deal with reauthorization every 2 years, or something like that. But in most cases, that is unlawful. There are some exceptions that come up are, and even for somebody like a janitor, let's say, which is, members of my union, if they work in a location that handles sensitive information, a government location that has sensitive information, there may be government regulations that pertain to anybody who works at that location. And in those cases, there can be a citizenship requirement.
Right. And that normally when they recruit for that position, it says this position requires by federal law, US citizens or only green card holders may apply, or something to that effect.
And just a reminder that disparate treatment need not be negative. And an employer is not obligated to sponsor visa holders as long as not sponsoring is non-discriminatory. Similarly on national origin discrimination, an employer can't say, for example, we really don't want to have Central Americans apply here because they have TPS and it's a pain to have to, do that reauthorization. Or I believe, that there are many more, if they're people from the Dominican Republic, they're more likely to be undocumented. And so we don't want Dominicans to apply here. Those are all forms of unlawful discrimination.
We do have a slide on pre-hire assessment as to what questions they could potentially ask in an employment-based, interview process seeking candidates. What kind of questions can be asked to find out whether an individual would require sponsorship, because you're not obligated to sponsor anyone, but across the board, you're not giving sponsorship. How do you find out, does this individual require sponsorship? We have these particular questions that could potentially be asked.
We have a question about the anti-discrimination provisions. The question is, how are these anti-discrimination provisions enforced by the applicants?
That's a good question. There is an office so obviously national origin discriminations can include a Title VII issue, and that can be EOC, but there is also within the Department of Justice the IER, the Immigrant and Employee Rights Division, and they will take complaints of this sort of discrimination.
How does their state, now New York State and New York City laws dealing with protecting immigrant employees, how are those agencies functioning? How are those laws functioning? Do we know in terms of the enforcement?
Well, the agencies that I'm familiar with are agencies that enforce employment laws on behalf of any employee, regardless of immigration status. And both in New York as well as elsewhere, agencies will take a complaint, conduct an investigation, prosecute if necessary, without regard to immigration status. Where the issue can come up is with remedy. And so but there are many reasons to decide whether or not there is in fact a violation of the law prior to getting to the issue of remedy. And oftentimes there's more than just the remedy to the particular worker at issue. Hoffman, which we don't have to go into in detail here, still applies. And so to the extent that somebody was unauthorized to work during a period that they were out of work, albeit for the employer's unlawful act,
that person will not be able to collect back wages for that period of time. And obviously, if they're not authorized to work, they can't be reinstated at the time the remedy is issued. But having said that, there's many other kinds of remedies that are available for employees.
So I guess my question is the same that Sudip posed earlier. Collective bargaining agreement, grievance, arbitration. What are the remedies for employees who are wrongful or alleged that they're wrongfully terminated because of discrimination? If they have like a pending case or investigation from an anti-discrimination agency, do they still have the 60-day grace period to find new employment? And if they don't, or if an investigation is pending by, let's say, the EEOC?
Well, I'm not, in your scenario, are you talking about somebody who all parties understand is not authorized to work?
I'm talking about someone who is terminated. They allege that they're wrongfully terminated and it's on account of discrimination because of their status. And they file a complaint that's pending and the EEOC is investigating that complaint. I guess they still have that grace period.
Yeah, they would really be treated as any other employee.
Mhm.
If whether or not they can, seek remedy under the collective bargaining agreement depends on how the collective bargaining is written and whether there are discrimination provisions under that collective bargaining agreement. If there aren't provisions under the collective bargaining agreement, they can try to seek remedy elsewhere. And then if they're reinstated for that, it would just be evaluated at the time that they're going to come back. Are they authorized to work? Were they authorized during the period of time that they were out of work so that they could get back wages? Yeah.
Like, how long would these grievance periods take? Like, if something is filed, does it take less than 60 days?
It varies widely.
So,
And so I will just give you an example. I mean, it varies widely. I would say that it's probably more typical than not that the grievance process itself lasts at least a month on the lower side and potentially longer before you get to the demand for arbitration. Then getting to arbitration, from the demand to arbitration, depends on the parties, the union and the employer, and what kind of arbitration form they have set up. Do they have a panel? Do they use AAA? Do they use some other agency? It can go quickly or can go slowly, also depending on just how many cases they have between them. So it wouldn't be that uncommon for it to take 6 months to get to arbitration. It also wouldn't be uncommon in many situations for it to take a year.
so for an employee, there's not really any immigration safeguards for those 60 days. If they go back to their country and it's taking a year, does that matter? Or like,
I mean, that implicates all kinds of other questions. I mean, in most cases, employees, while they're out of work,
and let's say they're outside the country now.
they have to be looking for work if they want to try to also get back wages.
Right.
Because there's a generally recognized duty to mitigate.
So it gets very complicated then with like a
Yeah,
grievance company.
in my experience, workers just don't go back to their home country and wait it out. That's not typically what happens.
Is what typically happens if they find a job or?
Yeah, they or they, in the union, in my sort of world, which is a specific kind of union and a specific kind of industry and sector, there aren't a lot of other comparable jobs that pay the same wages and benefits outside of the union context. So, our union represents janitors, security guards, people who outside of the union make pretty low wages and don't have benefits. So what typically happens if they get fired, if a worker gets fired from their job, is that they try to go find another one. They most of the time aren't able to find one that is really equivalent. So they will have earned something, but they won't have earned back their full wages.
What about temporary work? Like if they find temporary work, does a temporary job have to like sponsor them and they have to go through that?
Well, what I'm talking about are not people who are sponsored by the employer. They're just, workers that have authorization some other way.
Okay.
So if you are sponsored by an employer and covered by a collective bargaining and get terminated and go through the grievance procedure. In the meantime, your immigration status authorization, work authorization is lapsed. So technically you can't work in the US. An arbitrator then finds a year later, there was not just cause for this termination.
Right.
And that you're supposed to be made whole. The employer is going to argue, I'm guessing that, well, you couldn't have worked during this time anyways because your authorization had lapsed, but it was because the employer had terminated you unjustly. You know, the chicken and the egg.
Right, I mean, so, I mean, you guys can probably address the sponsorship issue and whether that sort of situation has come up in a sponsorship situation more than I can. But I mean, in a similar kind of setting, I'll tell you, I had an arbitration years ago in which somebody was discharged. She did end up getting an arbitration hearing, which did end up being about a year later. She did get make whole remedy, and that included back wages and reinstatement. For part of the period of time that she was not working, she was not authorized to work. She had then, though, gotten her green card prior to returning, and so she was able to be reinstated. But her back pay was heavily reduced from what the award was. Yes. So she couldn't get back wages, you know, essentially. I mean, I think we might have gotten some portion of it.
I think the issue in the collective bargaining context is, I think, Sudip, exactly what you said. You know, during sometime between the discharge and the arbitration, the work authorization expires for whatever it is, and then by the time you wind up in arbitration, the employer gets to argue, well, even if there wasn't just cause, this person has not been legally authorized to work in this country from this date. Therefore, no reinstatement. You know, no back pay following that date. So it's, you know, it's almost like it creates a moral hazard. You know, and I guess the same with the board under Hoffman and other things. So, you know, I guess the question for employees is like, what do you do? Is there a meaningful remedy there? Given that most arbitrators, no disrespect to any arbitrators, wouldn't, you know, don't have the guts to impose a meaningful remedy to say, well, okay, the person wouldn't have lost their authorization to work here, but for this improper discharge, therefore I'm going to stick it to the employer. Find me an arbitrator who will do that.
Well, this could be its whole separate panel, but I will just say that I don't actually think that the arbitrators are reticent to take the employee as the employee and judge on the merits, nor do I think the board is hesitant to do that. And like I said, you know, at the beginning of this section, this only comes up when you get to remedy stage. So, or in most cases, that's the way it should be anyway. And in my experience, that is what happens.
Before I forget, because we have CLEs for the people on Zoom I need to give you the code. And the second code of the day is LER-581. LER-581. So it looks like we have about 10 minutes left, and we have some more slides, I believe. Hot topics. How about that?
Hot topic. So earlier I'd mentioned about consular processing, and you go to the consulate and issue a visa and your passport and you come into America. What happens when you want to renew that visa? In the old days, you could actually mail your passport to DC and you could renew your visa and your passport stateside. And it was such a glorious time because you just mail it in, they got the visa and their passport, and then they could travel, not having to worry that they're going to be stuck abroad because there's a visa issuance delay, you know, causing a gap in employment. And so finally, they are bringing that back, which is very, very exciting. It's going to be a pilot program. They're going to start off first doing H's and L's. It's supposed to go into effect this fall. I don't know what the parameters of it will be, but everyone's very, very excited about this new development. So it's definitely a hot topic.
What's next?
How about immigration
Immigration
scams?
scams.
I'm not sure what the hot part is of this hot topic. And there was some news recently, but there have been historically, and there at various points there's upticks in people have what is called and commonly referred to in Spanish as notarios, passing themselves off as lawyers and trying to attempt to help immigrant workers get documents or find a path towards some lawful status, and essentially just really taking money. So it has been happening, but I believe we're in one of those uptick periods where it's.
There's also the phone scam where somebody will
Yes.
call you and say, I'm calling from immigration or the IRS, and we have a warrant for your arrest. I need your social security. You need to send X amount of money to Western Union, and then to clear your file. And they target people on visas. Obviously, there's been some system has been hacked. I myself have received a call, which I found very comedic, and had fun with the caller. But it's important, that employers are aware of this, employees are aware, so that the IRS and the government, they don't have time to call you. They're not going to call you. But if you're not familiar with that, it can set you into panic. So it's important that everybody knows it's not. If it does happen, you can report it to the FBI, and they'll look into it. They actually identified some scammers that were overseas, and it kind of went down. Now it's starting up again. Oh, that, and then the migrant workers.
Well, there also the other thing that happened very recently is that in New York, the Public Employment Relations Board put out a call for parties to submit amici on issues related to A&J Kirby Farms, Corbigelia Farms, and Lynn and Sons. And what it's requesting briefing on is two questions. One, whether seasonal agricultural guest workers who are present in the United States on H-2A visas, whether they should be included in a bargaining unit certified under the State Employment Relations Act that was amended by the Farm Labor Practices Act. And then secondly, whether the H-2A workers who worked for the employer at the time the petition was filed, the petition for certification was filed, but who have returned to their home countries at the time that the certification issued, would those be considered employees who are included in the proposed unit? So it's a question about what is the appropriate unit when you have a group of farm workers who are, some of whom are only there seasonally on temporary visas. And so it's an interesting question. And I'm not in this industry. I don't have more knowledge than that, but I think, sort of following NLRA logic, where there's a community of interest, if there's a reason to believe that the H-2As are going to return, they definitely should be included in the bargaining unit. One of the things that strikes me as interesting about this issue too is that I read recently, unrelated to this, that in agricultural work, I believe in California, but potentially across the country, only I believe 40% of agricultural farm workers are on an H-2A, and it may be possibly lower, meaning that the rest are not, which would lead one to believe that there's a high number of undocumented, majority undocumented in the fields doing that farm labor work. So it then seems to me kind of ironic if there were to be a holding that would exclude people who have work authorization from a bargaining unit that is created with majority of people who might not. That would be an odd result in my view.
Any other questions here? Any questions in the reverse?
Here's a comment. This is in fairness, in Latin America, a notario has a law degree, which is not the case of a notary in the US.
Correct. Which is one of the reasons there's that kind of confusion.
And okay, so I'll ask a question since we have 2 minutes left. Can a non-immigrant worker request unpaid leave?
Yes.
Yes.
Actually, so yes, if a worker is in an H-1B or any other non-immigrant visa status, they can request unpaid leave. What the employer should do in that situation is document it. Have the employee requested in writing saying, I would like to go on unpaid leave, my mom is sick, whatever the request is. And that's the employer's evidence that they were not the one to sit this worker out, especially in the H-1B context where a site visit could occur and where's the worker? Why is he not on site? Well, he requested unpaid leave, here's the documentation. And that's why I haven't paid him for those 3 months. Because when later on, when the government is looking at maintenance of status, they tend to look at the W-2 and see, you said you were going to pay them $85K a year. This W-2 says he earned 70 last year. Where's the rest of the money? Are you short paying this person? Well, no, he was on unpaid leave actually, and here's his request, and I granted it. So it just has to be documented.
Even if they go on FMLA, it's the same thing. It's kind of like whatever you do to Bert, you got to do to Ernie. So your foreign workers and your domestic workers, you got to treat them the same in that respect.
We have a question.
So I think you guys touched on it before, but the unpaid leave thing, so there's a 60 grace period. And if the worker says, hey, can you just leave me on payroll or my employee? I don't want him not be employed. Can you put that person on unpaid leave until they get a job?
The employer shouldn't put the worker
Or
on paid
the worker asks them, hey, can you just put me on unpaid leave until I get a job? Is that okay?
That's a different fact pattern.
Right.
If
That's what
the
I'm
person-
that's why,
right,
that's
if
the
the
question.
person is no longer
why
your
you're asking.
employee,
Yeah,
essentially the person saying, can you do me a solid?
right,
and
exactly.
keep it
And
there.
it's like, hey,
So-
I will tell you this request. It's from me,
I
employee.
think you gotta follow those are different rules. you
Yeah,
need to
yeah,
follow.
that's what I'm
So,
asking.
Yeah, that's an inappropriate ask.
Okay,
Yeah, the employee should be concerned because when they file, let's say they get that next job, when that employer files, they have to show maintenance of status by showing pay stubs. That's normally how you show maintenance of status. Now you have pay stubs from last year and what have you been doing? That's gonna raise up a whole question on USCIS to kind of find out. You're like, I was on paid leave for 5 months. And now you
Exactly.
look for a job. What happened there? Why did you go back to work? So it's,
it's
So it looks like we're out of time unless there's any last questions. And thank you all for coming.
Evaluations.
It was a Supreme Court case in 2002. 2002. Okay. And, it's